I had never seen such a powerful lobby. Who said this? And you data protection geeks, someone can remember this quote. I had never seen such a powerful lobby. That was then the Commissioner of Justice, Vivian Reding, back in 2013, talking about the lobby on the GDPR. She was referring, I believe, to the lobbying from the industry, but as Paul said before, of course, the lobby of the states in a different direction were also very powerful. And to some extent, I have to admit that we, as a smaller civil rights organization, did our best to bring and to have the best GDPR possible. But what we achieved, it's a sort of a regulative, as we call it. It is a regulation, but it has more flexibilities than the former directive had articles. So Paul mentioned a few things where member states can implement it differently, and there are many others. As you can see there, you can already follow the slides on your computer. They are already online, and you can follow them now, or even pretend that you're following them and do something else if you're bored. Let me introduce you briefly who we are. So we are a network of 39 NGOs. We were 35 until last week. We had our GA. And now the Free Software Foundation of Europe, None of Your Business, which is the Max Schrems new NGO, D3 from Portugal, and NextNet from Catalonia are now new members of our network. And I work for the Brussels office here to advocate on data protection, privacy, and also copyright. I will skip this. You know already a lot about data protection and privacy, but that was just for to have a general view. As you know, the GDPR is actually technically enforced already, but not being applied until May. And we are now discussing the privacy regulation, which will complement the GDPR, and which is also heavy lobbied, a bit less publicly than the GDPR, I believe. Now it's less Facebook and Google advocating about it, but the advertisers and publishers, meaning that the duopoly of Facebook and Google are the heaviest fighters in this fight, which is somehow under the radar compared to the GDPR. I'm going to talk a bit about first of the negative aspects of profiling, or which are the societal aspects of profiling, why this is important for us as a civil rights organization. This is going to be the structure of my presentation first. So personalized experiences and discrimination. Then we'll go into a bit of profiling, what Paul already mentioned, but with a bit of an insight on the rights of the data subjects, which is the core of my presentation, and how to do this legally, if it can be done legally. So generally, profiling and especially algorithms are the new magic potion for many policymakers. They want to fix everything, all of our societal problems, with this thing that we call algorithms. So now, in order to prevent crime, in the UK, there have been experiments on predictive policing. So if you have seen the movie Minority Report, that's already happening. So that's a thing of the past already. So what they do, according to algorithms, they send police patrols to certain areas, mostly to locate crimes that create more societal risks or more sense of alarm, such as drug abuse or petty crimes, such as robberies and things like this. What happens with this algorithm? That, of course, police was going more to poor areas in the UK, because these kind of crimes are committed more in these type of areas, because the police was going more people were caught, more people went to prison. When they were released out of prison, new algorithms that are used in order to hire people in job recruiting processes and detect that they have been in prison, they go back to poverty and they go back to crime, and this is an endless circle of poverty and crime. I haven't seen any example of predictive policing that takes the police to Wall Street or to arrest bankers. So I guess it's a matter of choosing the right algorithm. And credit score, I think Paul was mentioning it before. So you know what it is. I'm going to speak in a while an example we have on social services, so how people can apply for certain welfare benefits. And I also deal with issues related to illegal content. So when the European Commission wants to prevent hate speech or child porn or any other thing that's evil on the internet, they think algorithm is the best way to solve it. And also for copyright infringements, in order to prevent copyright infringement, they believe now that installing upload filters is the best solution to solve it. I disagree that's the best idea, but that's how it is currently. So some examples. Cambridge Analytica made my presentation more interesting than before because I don't have to explain what is bad about profiling. So thanks Facebook and Cambridge Analytica for that. Well, we saw that Facebook, since you signed, if you're members of that network, and that Facebook can use your data for research purposes. According to Facebook, that includes finding vulnerable teenagers in order to show them some type of advertising. They also ran a fantastic experiment showing positive things on your feed to some people, to some thousands of people, and negative ones to others. And they saw that by the end of the day, people were happier or more sad, depending on what they received. So they experimented with you, so you can thank them for that. And the example that I wanted to bring on social services is one that our member in Poland did, Panopticon. They analyzed how algorithms are used currently in Poland in order to say yes or no, you can receive certain social benefits. They have seen that there are no transparent rules for this, so there were some mothers that wanted to receive, let's say, social housing or perhaps some unemployment benefits, and they say, okay, according to our algorithm that I don't know how it works, you are denied of this social help. And it's not more efficient than the office worker because, as Paul explained before, the office worker could be generally more able to explain why you are not you cannot receive this social help. But in the era of algorithms, they will tell you, "I'm sorry, I cannot give you this service, and I don't know why." The new system of distributing labor market produces new victims because and those of them who were able to receive the support before, they're not receiving it now. And finally, well, it's a system which is based on a presumption of guilt. So the person who is unemployed is there because he or she does, or all, as Paul said before, and they don't want to work, or there is something wrong in their habits that prevents them from getting a proper employment. And now we're going to the second section, so definitions and rights of individuals. I'm going to split this into 4 parts. So first was profiling and automated decision making. I know that Paul went through it, so I'll probably go faster on that part. And general provisions on profiling and automated decision, some specific provisions on automated decision making, and finally a bit longer on the rights of the data subject. So what's the definition of profiling? Well, the goals of profiling are well described there. So the transparency and fairness safeguards, design increased accountability obligation, specified a legal basis with I, not with E, for the processing, and the rights to oppose profiling, as Paul was mentioning before. And if certain conditions are met, and there is a need to carry out a data protection impact assessment. And the article 4 of the GDPR then explains how profiling is composed of 3 key elements. It is first an automated form of processing, so it's not just done manually, but it's automated in one way or another. It has to be carried out on personal data, of course, and the objective of the profiling must be to evaluate personal aspects. You need to know that, yes, that the Article 4 refers to any form of profiling, not solely automated decision-making. and human involvement does not take the processing out of the scope of this protection. So what does this mean in practice? According to the Working Party 29, it's a procedure which may involve a series of statistical deductions classifying individuals based on characteristics such as their age, sex, profiling, regardless of any predictive purposes. So anything that an algorithm is going to say, you are a woman of this age with this purchasing power and with these sexual tendencies, and you might or not be employed. If you are employed, you are in sort of this kind of classification, and therefore I will probably try to sell you this sort of object in advertising, for example. I'll give you a mortgage or not, or increase and the amount of money you have to pay for insurance or any other thing. Okay. So these inferences are usually done on how an individual or a defined group of individuals can be placed under a certain category, regardless of that category is right or wrong. I might be placed in some databases somewhere where I am one type of person, in another and a different person. But first of all, I don't know that database exists. Second of all, I cannot do much to change that classification. But generally, what they want to do is, so what kind of a behavior you may incur according to the way you drive now with smart cars, and they will be able to sort of predict or imagine what kind of insurance you should be paying. As I mentioned before, your interest, Facebook is probably the best example for that. What kind of person you are, what kind of potential buyer, that's what they want to know you are. And the analysis, of course, of past behavior. So there are some algorithms also being used now to decide what kind of performance has been done by one worker. So people are being hired or also fired according to these black and hidden algorithms. Specifically, automated decision-making is one of the aspects of profiling, can or not be leading to profiling. But generally, it's the automated decision-making which is using technological means, makes in computers, in a way. Can lead to profiling practices or not, as I said. And for example, I was mentioning here the assignment of seats in a theater. It can be randomly assigned, or maybe if you log in and they know that you are a good customer and you can usually go for the higher prices, they will give you by default a best seat in a theater or not. Or perhaps your membership card, your loyalty card in the supermarket will give you to discount on some products or another. How can profiling be used? Well, again, we really need to make the differentiation that Paul did to some extent before. One thing is profiling, another thing is then decision-making based on profiling, and solely automated decision-making, including profiling. In Article 22 are three different things. In a way, so decision-making based on profiling is, for example, when someone wants to, a bank officer, a person wants to agree or not to give you a mortgage, so that's the decision-making based on profiling, but not necessarily using a computer. And solely automated decision-making, including profiling, is when this machine that the clerk in the bank is using tells him or her or all and that you can get a mortgage or not. What the GDPR provides is a general prohibition on fully automated decision-making, and that has, including profiling, that has a legal or similarly significant effect. This brings, I guess, a lot of question marks in your brain, but at least it has some exceptions that we will see in a minute. And what it says in Recital 71, the measures need to be put in place to safeguard individual rights and freedoms, and also the legitimate interests, meaning legitimate interests of businesses mostly. What does this legal or similarly significantly affects him or her mean? Well, legal effects can be social benefits, border crossing, targeted surveillance, or some increased security checks in airports, for example, or also breach of contracts. Are you likely to breach a contract not to pay a mortgage because you are a young person who is unemployed? Probably yes. So that's one of the legal effects. Something that can significantly affect you It could be well, credit applications and then the e-recruiting practices. So when you submit a PDF or an application online to find a job or to postulate for a job, and then this algorithm decides, okay, this person is likely to be interviewed or not, and then you will get the interview or not. One key aspect to ascertain to know if this similarly significantly affects him or her applies is it must be sufficiently great to be worthy of attention. So it must not be, okay, and the traffic light next to your house is going to take longer or shorter for you to cross. So that kind of thing is irrelevant for data protection. It must influence the circumstance in the behavior and choices of the individuals concerned. And in an extreme case, and that could be the most extreme degree, it could lead to exclusion of or discrimination of certain services. For example, it could be as the social services I mentioned before in Poland, but it could be also not being able to access a platform, a networking platform such as LinkedIn, for example. Privacy International made a good point regarding the risks of automated decision making, and mentioned that targeted advertising has a strong potential of exclusion of or discrimination of individuals. And they were mentioning this study from the Carnegie Mellon University, where Google was showing ads for high-income jobs to men rather than to women. That, of course, they can affect you significantly, because you can see or not that a job is there for you, and I might be able to get it before you just because you were not shown that ad. Then, which are your rights? We go directly now to see what you can do to oppose this, or at least to know what's happening in this black box, or someone said probably you should call it just secret boxes, because actually black boxes in planes are orange. And so the right to be informed, and that's the first of your, yeah, that's a fun fact, yeah, they're orange. So you can find them when it's in the snow, you can find the black boxes easily. So right to be informed is the first of your rights. Controller must tell you that they are doing this automated decision making or profiling. They must explain what's the logic behind this algorithm or this process. So it's not, okay, this is the algorithm, 2 pages of mathematical formulas, and good luck. No, they need to tell you, okay, we're using, so how fast you drive and what kind of, what's your age, perhaps even your gender. And we're using certain criteria in order to charge you more or less for the insurance, for example. And finally, well, explain which are the consequences expected from such processing. So I can charge you more or less, I can just deny you from being in this service, or any other consequences that might result from this profiling. All of this is covered in the right to be informed. Then also, well, regarding the meaningful information, the information needs to be provided by individuals. So what kind of information you are providing as an individual to this platform, to this algorithm. They need to tell you what kind of information they need from you. They need to tell you what kind of information from previous conducts they are taking into consideration. For example, if you were delayed paying a monthly statement, they should tell you that that's part of the decision they're making, or that the algorithm is making. And another example is the use of official public records to show insolvency, for example. That's another way of doing it. Another example of significance and envisaged consequence could be, well, by monitoring the purchase behavior in an online platform, they could propose premium accounts to those users that engage in impulsive shopping, or could show you some different less premium account if you are more careful one. I want to get the best bargain all the time. The right of access, a different right in Article 15. So in this context, well, would be to access the data. What kind of data they have about you, I want to know, and to be able to receive, even to download it if it's possible, what kind of data you have about me. So that's one of the rights that are now even more enshrined in the GDPR. The right not to be subject to this decision-making, basically solely on automated decision-making. The Article 22 provides this exception to obtain human intervention, as Paul was saying before. It could be useful or not. Someone say, I'm sorry, I just don't know what to do. The machine is telling me this. But ideally, they should be able to express why it is happening, and then you should be able to contest that decision. More importantly, perhaps more famous are the right to rectification, the right to erasure, and the right to restriction of processing. And the Article 29 Working Party says that this right of restriction of processing applies to all stages of the profiling process. So when the input comes, when the processing is being done, and also for the output. So in all of stages of the profiling process, you should be able to restrict this processing. Yes. And the right to rectification and the right to erasure applies also to both input and output. So you can get additional information in order to correct an algorithm that's concludingly saying that you might incur in a car accident in a few years. So you should be able to correct that so you're not charged more. Well, I don't know why it's repeating. And then finally, the right to object. Well, the data subject has the right to object unless the controller demonstrates compelling legitimate grounds. Was that? I don't know. We don't know. Probably business know. Which overrides the interest of the data subject. So we'll see that in practice. We'll see what the DPA does. I expect much for many DPAs. I expect less from the Data Protection Authority in Ireland because of the past conducts. Perhaps that's changing with the European Data Protection Board. We'll see. But there's something important. There's an absolute right to object to direct marketing processing activities. That's something which is very clear, and there's a little controversy about it. So can profiling be done legally? We need profiling for some businesses. Is there any way for businesses to do it in a business or a public organization, or even NGOs perhaps, that want to do it in a legal way? Well, yes, you can do it when the data protection principles are applied and respected. So there needs to be a lawful, fair, and transparent processing. There's going to be just, I put this algorithm here because I prefer women working for me, or men, or people of a certain age. That cannot be allowed. Further processing and purpose limitation also apply, so you cannot use the data for whatever you want, but for the purpose that you are collecting it, and you cannot transfer that data somewhere else just because you like it, or because you want to earn more money. Data minimization, don't collect everything. Just do you need the address for that person for this processing for your loyalty card? Perhaps not. You just need the number of that applies to that customer, and then you can do the profiling for the loyalty card. You don't need any more data. The accuracy, that's very important. So what kind of the data is accurate about you? Again, as I was saying before, I'd like to be, if I'm classified in one way, I'd like to be at least classified correctly and not being placed in one position of risk just because someone did the algorithm incorrectly. And the storage limitation is very important. So how long you're going to keep the data, and why are you keeping it for so long? Also, there needs to be a lawful basis for processing. Consent is one of them. And there are new guidelines from the Article 29 Working Party on consent that were published this week. And the user needs generally to have a real choice and no imbalance of power. May 6th, I was speaking with someone in the coffee break now, and she was mentioning how she was asked by Facebook yesterday, hey, do you want me to be able to use these biometric features on Facebook? You can say yes, or you can say yes, because by saying no, you need to apparently to delete the account, if I understood correctly. So that's not a real choice, because you might not want to be out of Facebook just because you don't want them to use your facial expressions, right? It needs to be necessary for the performance of a contract. That could be one of them. Attention. Just one of the examples is processing data from a credit card. That's necessary so you can buy something. But it's not Amazon suggesting you, okay, you bought this book, you might want this or not, these other products. That's not necessary for the performance of a contract. It's a feature that I like a lot, but it's not necessary for the performance of a contract. It can also be necessary for complying with the legal obligations. So if a bank needs to do some sort of profiling or automated decision making in order to prevent fraud, they can do it. It could be also necessary to protect vital interests. So if there's an epidemic and there's some data that can be used in order to prevent that an epidemic is spreading faster, of course that should be one of the legal grounds, and that's okay. Again, also necessary for the performance of a task carried out in the public interest or exercise of official authority. I don't know what that means. That's one of the ways in which a member state can escape proper protection. They can say, yeah, we need this in the public interest, or I guess some companies can do that. We'll see how that works in practice. I don't think we have enough information of good practices on this ground. So we will need to see after 25th of May. It could be also necessary for the legitimate interests. That's an interesting concept that we were actually fighting during the GDPR negotiations. We thought it was a concept that was too vague and could lead to imbalances of power. It could be to Facebook having their legitimate interest to earn more money, or the Google their legitimate interest to read your emails so they can sell you advertising. So we'll see how that works, but it's interesting to know. Well, it does not apply automatically. It's not because you say it, you have the legitimate interest, it's already okay. There needs to be a balancing exercise required. So what's the detail of the profile made? What's the comprehensiveness of that profile? What's the impact of the profiling on the individual? And which are the safeguards for fairness? So all of that needs to be taken into consideration when you want to use that ground. Third, it needs to ensure data subject rights generally, so that's obvious. If you are using one legal ground, but you don't allow people to rectify or to access their data, then that's not done legally. And you might need to prepare a DPIA. So so one evaluation of these aspects that are being taken into consideration in order to do the profiling. So yes, and finally, so these are the four grounds. It's legal when data protection principles that I mentioned, Article 5 mainly, are applied. There needs to be a lawful basis of processing. It needs to ensure data subject rights, and you might need to prepare a DPIA according to Article 35. So with these four grounds, if you need to do profiling, be very careful. There are wonderful high sanctions, up to 4% of the revenue of your business. So be careful, but if you have any questions, I'm glad to help. I think I was relatively fast, I hope. Thanks to Paul that did everything. So thanks a lot, and I'm available for any questions.